I have been counseling three or four families who are going through very tough time due to untimely demise of their core family member. And since they did not have life insurance or will and estate document done, they have to go through a lot of hardship. So even though person has lot of assets or they earned a lot and saved, but still due to these documents and this preparation is not in place, they had to go through a lot of struggle and a lot of anxiety. And we can save ourselves from all this by taking few simple steps, and that will make everything smooth, because nobody can be sure when any unfortunate event like death can happen to anyone. So, and it's certain nobody is immortal, so everybody will die one day. And it's not that we will die like without any assets. During our lifetime, definitely we'll have something acquired materially, and that need to be transferred in an efficient way to our next generation or charity or whoever we want it to be. But if we don't take these necessary steps now while we are alive and healthy, then all of that will become a nightmare for our family members, those who are being left behind. So even though we work hard, even though we have saved, even though we have invested, uh, and like all our life, if we don't take this one important step right, then all of that is like, it's at risk to pass on to the next generation or pass on to the uh, our desired beneficiaries in a smooth manner. It will happen, it may happen, but it has to go through a lot of legal hoops, and it will cost a lot of money and anxiety to everyone. So, with that objective in mind, I just want to share few things about how this can be done, both in India as well as in US, why it's important, and then we can have some question answers, and then I can also share some options with you how it can be done both in India as well as in US. And nowadays, with the help of technology and everything, all of this can be done just by sitting at our home. So it's very simple to do it now. And against the like some common notions that this wheel and everything is not for me, it is only for the people who have some dispute or who has some problem in their family. Only those people need that. So that is just a myth. That it's not like that. Everyone needs it because you will not be able to transfer your assets to the next generation without having these documents properly. And we will go through that in detail and discuss what assets are not applicable for will and what assets are applicable for will. And then you can make a judgment yourself that whether you need it or don't need it. But in my opinion, practically everyone needs it. I think there is no exception to it. So let's dive in, and I will just try to keep it very simple and short, so that we just get to the bottom of the issue, and then if there are any questions, then we can take it at the end. So just a disclaimer here that this session is only for information and awareness and education purpose only. So whatever you do with your financial decisions, you should do it with proper consideration and with proper advice from a professional. So today we are going to cover why is will and estate plan is important in US and who needs it for sure, and for whom that may be an optional thing. But as I said, there is no exception to it. So we'll see it, and then how to do it. Like, okay, we understand it's need to be done, but then how to go about it. And same thing we will discuss about India, like in what situation in India it is required, and how we can go about doing it. So just to understand a very high level process, what all steps are involved in planning for will and estate. So very first step is create a financial asset inventory document. What it means that you have a document which lists down all your financial assets, including your bank accounts, your investment accounts, your retirement accounts, your real estate properties, any S corp or business investments you have, any loans you have given to anybody, any credit cards you have, so a social security account. So anything and everything where you have some kind of financial interest, whether in terms of liability like mortgage account or loans, or in terms of assets like savings, investments, or movable and immovable both. So you should have a proper list of document, a list there which lists down, okay, this is the asset in this institution it is. This is the contact information, website or phone number of that institution, and this is the account number or the identification information for that particular asset. You don't need to mention the amount in that particular sheet because that will keep changing with time. But identification information should be there. And as and when you keep adding any assets or keep closing any assets or moving any assets or disposing any assets, you should keep this document up to date all the time. And you should have it shared with somebody in your family. Ideally, I would say that you should put it on a secure cloud somewhere and then share it with somebody who you trust within your family, or maybe a one person outside your family as well. And as I said, you don't have to mention any values in there. It's just identification information. So it should not be any concern to document and share it with somebody, because I have found families, practically, it's true that person has died, the core member in the family has died, and family has no idea where all he has invested, where all the assets are, what are different accounts are, what is the laptop password, what is the phone password, have no clue at all. And even though they were working and making six-figure salary and have living a very lavish lifestyle, all of a sudden, family has no access to any resource at all. So it's very, very unfortunate situation, and many people have this kind of habit that they just keep everything in their head, or even if they have documented, they have not shared it with anybody. So then it is of no use because with you, that information is also gone. So just make sure that you create a full, proper document and a nice inventory of all your financial assets, and including life insurance policies and everything, like anything which is related to any assets or any liability, and keep it always current. It won't take much time. It is like a one-time exercise, and you can just update it once in a while whenever you open or close any accounts. So it's a must thing. Everybody should do it. And if you've not done it, that is the first step I would say everybody should take. Then next step will come, identify which assets can have designated beneficiary. So for example, whenever you have a 401k account in your company, it forces you to select a designated beneficiary. Whenever you apply for a life insurance policy, it forces you to select a designated beneficiary. So these are the kind of accounts where you can nominate a designated beneficiary right at the time of account opening. And if you have a designated beneficiary, then you can avoid the probate or court process. And after death, if you have the knowledge about that account and if you contact the institute and produce the death certificate, they will transfer that account to you after identifying your identity. But nominee and beneficiaries are different. So nominee is not the beneficiary. We will come to that when we come to the India context, because in India, nominee term is more common versus beneficiary. So we'll understand the difference between the two. So update beneficiary. That is next step. Then for all other assets where you don't have any designated beneficiary already documented, you identify a beneficiary of that account in case anything happens to you. Whether you want to just give it to your spouse, or you want to just give it to your kids, or you want to give some asset specifically to somebody or some charity or whatever, then you designate a beneficiary for all those assets. It could be a default beneficiary that, okay, everything by default goes to my wife. If my wife is not there, everything by default goes to my kids. It could be like that. Or it could be very specific that this particular thing should go to that person, or this particular account should go to that person, like that. Then you identify an executor of the will. Like who will be the executor of the will if I'm not there? Because will is just a document. Somebody has to still act on it and make sure that whatever it's documented in the will ultimately get executed. So that person is the executor of the will, and that can be any trusted family or friend. And you also need to mention a contingent executor, because what if your executor die before you? Whatever, whoever executor you name, he may pass away before you. So always have a backup executor as well. And this executor should be, in most cases, younger than or of same age than you. Because if you identify some older person as your executor of the will, then most likely he will pass away before you, and then you have to update the will again. So we don't want to do that. So try to identify somebody who is of around same age or younger than you, who you trust from your family or friend, and then always have two executor, one main executor and one contingent executor. Then you identify a guardian for kids. Again, it's very, very important thing. If your kids are minor, less than 18 years of age, then you must identify a guardian for your kids. And again, in that you can have multiple, like you can have a backup guardian also and a main guardian. Then you should have a default clause for all future assets or anything which is not mentioned in the will. So because you may list down some assets in the will if you want, but all you can have a generic clause which says that any current assets or any future assets I acquire during my lifetime, same treatment will apply to everything. So in that case, if you acquire new assets in the future, you don't have to update your will. It will still hold true because of this default clause. And then, as I said, in today's time, it can be done online, so you don't have to go anywhere and visit any lawyer's office or do anything like that. It can be completely done from the comforts of your home. After that will is get drafted, you are comfortable with the wordings and everything, you validate and make sure it's correct. Then it can be printed out and it can be notarized and witnessed in US, or it can be registered in India. So this is just the last final step where you have to have some physical contact with somebody, and you just get it formalized after you have drafted it and got it printed. And then most important final step is then you share this copy with your executor who you have identified in the will, that hey, I have created this documented, I have named you as my executor, so you should have knowledge about it. So if anything happens to you, he immediately knows that yes, this document is there and I have to act according to that document. And then you can also keep a hard copy, original hard copy, which is signed in a safe way with your family. So this is like the basic step-by-step process to go about it. Now, if we talk about US, specifically in US context, so why the will is important and estate planning documents are important? Because as I said, everyone will die one day with some assets. I think there is no exception to it. We all agree to that. And it's very important for anybody who's having a real estate, like a home or a land or things like that, or a shop or things like that, immovable property, because accounts and all may be little easier to get transfer and everything, but real estate is really a mess if you don't do it. And let's say if you have minor kids and both of you, like your house may be in your and your wife's name, but if both of you unfortunately pass away in some road accident or something at the same time, then if your kids are minor, then they will not get access to your home or your real estate unless that is protected inside a trust. So that's where it's very, very important in US that you have a trust document in which you nominate the guardian for the kids and then move that house inside the trust, so that without any court proceeding, without any attorneys involved, your kids will have a home and everything can be settled smoothly, and the guardian can take care of the kids without any legal problem. If you don't do it, if there is no will, no trust document, and you just pass away, then after death, all assets will go to estate, your estate. Each individual in US will have a estate. And every person who dies, by default, everything goes to the estate. And then it is distributed as per the state laws. So all 50 states have their own laws. And according to that, then it will get distributed. First, all your debt will get settled. So like your mortgage, your credit card debts or auto loan, any loans, any kind of debt you have, that will get settled from your assets. And then remaining assets will get distributed as per state law. If state law say that everything goes to spouse, so everything will go to spouse. If state law say that it should distributed equally among spouse and the kids, then it will get equally distributed like that. So just imagine that even let's say you pass away and your spouse and has two kids, and state law say that everybody should get equal share, then your minors will get 33% share. Let's say if you have two kids, but then your spouse will be left only with 33%. So that may not be ideal situation. If kids are small, then you want more money to be at the disposal of a spouse so that she can take care of kids very nicely. So things like that. Then you have to involve lawyer and court. Without attorney and court, you cannot get anything done. It has to go through probate process, and it's a very lengthy process, very costly process. It can take months and months. And during that period, everything will be frozen. All your accounts will be frozen. You will not be able to do any transaction at all, including bank accounts or investment accounts and things like that. So that means you will be totally at standstill, even if you have like hundreds or thousands or millions of dollars in your account, but on paper you will be like with nothing until all that process gets settled. So that's why like it's very, very important. You can save yourself from all these hassles just by doing this one simple thing. So what all is involved? When we talk about will and estate planning document in US, there are four sets of documents which are required. One is the will document. As I said, there is no exception to it. Everybody must have it. Then health power of attorney. This is the power of attorney which tells, let's say, if you are incapacitated due to some health condition, then who should be taking call, who should be taking the final decisions about your health condition, whether you should operate or not, whether you should get organ transplant or not, whether you should get blood transfusion or not, whether you should be put on ventilator or not. So all those kind of critical decisions which are related to your life are in the hands of that person who has the health power of attorney. And if not, then doctors are free to make judgment based on their own will. So if you have any specific wish that okay, this is what should happen to me in case of any such situation, then all those things you can document in health power of attorney. If you have any last wish, if you want you to be taken care in certain way, if you become like terminally ill or in a hospice like situation or something like that, then you can document all those wish in this power of attorney and nominate a person who should take care of it. Or even if that person is not there, if you have health power of attorney and if a doctor can look at it and they will honor your wish as per that. Then another document is durable or general purpose power of attorney. This is also must for everybody. So this acts for all non-health related issues. So for example, let's say if you become incapacitated, you got a stroke and now you're not able to make your own financial decisions. You can't speak, you can't make your decisions. So you got dementia, Parkinson, or anything like that. Then in that case, this person who you nominate in this power of attorney can speak to banks, financial institution, life insurance companies, or anybody on your behalf. And then they can conduct the transactions on your behalf, whatever is in good interest for you and your family. But if this attorney, power of attorney is not there, then until you die, nothing can be done. If you are not able to make your own decision, then your accounts cannot be operated by anybody else without the authority of this power of attorney. Then last but not the least is revocable trust. Revocable trust means that you can change the terms and condition of it any number of times as you wish, as long as you are alive. And this is must for anybody who has minor kids. Because as I said, will and this power of attorneys will not save your kids going to foster care if both of you are not there. But this revocable trust will save from that. So once you have this revocable trust, then you can transfer the title of your primary home into that trust. And then you can nominate the guardian for your kids and again backup guardian for your kids in this trust. So if anything happens to both of you, then that based on this trust document, guardian can take the custody of kids and house will remain with the kids and the guardian. Like it will not have to go through any probate process. Otherwise, it has to go through the probate process to get transferred. And since kids are minor, that house cannot be transferred to their name directly. So everything will be in a limbo state until the kids becomes major. So then final step comes is how to do it. So it's very simple. Multiple ways are there. I'm just listing it down here. So if you have legal plan benefit from through your employer, then you can make use of it. All legal plan covers all these four documents completely free of cost. So only thing is that you should enroll in this plan and then you should pay the whatever the charge your company is charging. Generally is like in a range of $7 to $10 per bi-weekly. So on a yearly basis, it comes to around $300. And but then you can get it done free of cost. Uh, but only thing is that you have to visit the lawyer office, you have to find someone, you have to get through their contacts, and then you have to meet with them maybe a couple of times and then get it done. So that is one option. If you have not this, if you don't have this plan, I would highly recommend to not wait for it until next year or something like that, because as I said, we never know when the last day of our life will be. So don't make that mistake. Second best option is to get any local attorney, any family practice attorney in your town. But that would be very costly because any in-person attorney will charge minimum like $1,000 to $1,500. Like thousand also I'm saying less. Minimum maybe around $1,500 to get these documents done. So then third best option we have is online do it yourself kind of thing. For most situation which is kind of simple, straightforward, it can be done online without any much problem. And just to felicitate that, I have partnered with trustandwill.com. So it's a very trusted online name for years in US, and they have very good website and very good interface, which is like very easy to use, very user friendly, and anybody can use it and get their documents done by themselves. They have a very good support in terms of both online support through AI chat, and also you can talk to a real person if you have any questions. And I have negotiated with them. So if I get more than 15 confirmed cases, then we can get up to 25% discount on the retail price. Their retail price is $599 for all the four documents for the couple. And for will only, they have $299 for the couple. So if we get 15 confirmed cases, then we can get like everything at 25% discount of that price. And I can also then be involved to oversee and answer any questions if you have along the way. And if you just if that is not the case, then I have the liberty to offer 10% off to everyone. So if you just want to do it yourself and if you don't get 15 confirmed cases, then reach out to me. I can still offer you 10% off on Trust and Will. So that 599 you can be able to do it in $540. So these are all the ways through which you can get it done. And as I said, it's very easy to do. Fastest and most efficient ways to do it online yourself. That way you can just get it done in next 1 week or so and be done with it. So that's what I would recommend. Now, if we come to India, then things are little more, I would say, dynamic and little more complex. So same points which we discussed in US context, why will and estate is important. So it's very important for everybody because everybody will die one day. And in India, unlike US, after death, all the assets are distributed as per Hindu Succession Acts or Muslim law. So depending upon your religion. So in India, we don't have universal civil law yet. It is not a reality. So based on your practicing religion, your succession will be determined, and it's very very complex. It's not that easy. Like if you don't have it, then everything will go as per Hindu Succession Act or Muslim or depending upon your religion. And then same thing there also, lawyer and court has to be involved if you don't have the will. And it's again very lengthy process, much more lengthier than the US. And your physical presence is required. You are in US now. Let's say if your parents are in India, they have some house either from their parents, like from your grandparents, or their own, and they have assets. mutual funds, stocks, or any fixed deposits, bank accounts, or anything which they want to give to you. But if they don't have this will document in place, then after their death, even though if there is no dispute in the family, nobody can get any property transferred to their name. You have to go through the court process, and very first thing then you will need from the court is succession certificate. And that succession certificate will come as per the Hindu Succession Act, in which each of the descendants of that person. So let's say if it is grandparents' property, then all the sons and daughters of the grandparent, then their children, their grandchildren, whoever is there in that family tree, everybody will have a share in it. And then without physical presence of each and every one, nothing can be done. Because every first the succession certificate will be issued by court, which will say all these are the legal heirs. Then after that, since it's a property, let's say then that house cannot be divided into 5, 10, or 20 people. Obviously, one person or couple of person would like to take control of it. So then everybody else has to sign that we give our share or we just forego our share. We are fine with that. So everybody has to sign that affidavit. Or if there is any dispute or if somebody has some demand or something, then that has to be settled before that affidavit can be signed. So all that is very, very cumbersome process and cannot be done without physical presence. You have to be there in India. You have to attend the court hearings. You have to go through the lawyers and sign those all those affidavits, get it done, and it can take months and months. And again, same thing, no transaction can be done, no property can be sold, no transaction can be done in the accounts until this thing get cleared up. And you may lose tax efficiency in case of large assets. Like if you are getting a large inheritance in India, then you may lose the tax efficiency in that without doing all these documents. Because if you do this document, you can do proper succession planning and you can have your structure according to the size of assets which you have. Like either you can have a Hindu undivided family HUF, or you can form a private family trust. So with that, you can have a very good tax efficiency to get these assets transferred to your name. And then also, like if you are planning to stay in US, you are planning to remain here, your children are planning to remain here, then ultimately one day you want to wind up all those assets in India and bring it here. So if you have all this document in place and then everything get transferred smoothly and you have already HUA for private trust set up and everything is nice, then it will become like very easy thing to bring all those assets here, liquidate and bring it here. Otherwise, it will be like an impossible task. Like it will take forever, and you may not be able to get it here anytime. So, and it's not just applicable for your parents or your in-laws, but it's also applicable for you if you have assets in India, especially if you have immovable assets in India. Like if you have any land or any house or anything like that, shops or anything like that in India, it's very, very important because being an NRI, you are here. If anything happens to you and you don't have a will or succession certificate, anything like that documented, then all your children's, grandchildren, everybody has to go to India to get that settled. Without them going there, nothing can be done. So it will be a very, very tough situation in that scenario. So it's best to get it done for both your parents, in-laws, and yourself as well. And then, as I said, like everybody with any assets, financial accounts, bank locker, etc., need it. Like in India, almost everybody has some kind of bank lockers. Again, that bank locker cannot be accessed or opened by anybody if you don't have this will document. Bank accounts, mutual fund, demat cannot be transferred. So we have this myth, big false assumption that nominee is there. So then that means I will get everything transferred to my name. It's incorrect. There is a difference between nominee and the beneficiary. Nominee is just a person who is like an executor in the will, which we just discussed before. So nominee is the person who is authorized to felicitate the transfer of that account as per the wish of the will. And if there is no will, then as per the Hindu Succession Act or Muslim Sharia law. Explaining an example, let's say your father has a mutual fund account with, let's say, 10 lakh worth of investment in it, and he has made you as a nominee of the account, and then he pass away without a will. and you have two siblings or three siblings, then after his death, it's not like that you get that entire account. If you are just a nominee, then it's your responsibility to transfer that account into all his legal heirs. And all those legal heirs will be determined as per the succession certificate, which you have to get it from the court. And based on that, then you have to distribute that 10 lakh worth of account into all those legal beneficiaries. So this is a very big myth everybody has, that okay, if nominee is there, then we are safe. We don't have to worry about anything. So that is not the case. It's a beneficiary which counts, not the nominee. And generally on mutual fund accounts or stock demat account, you don't have any beneficiary. And most of the bank accounts also, you don't have any beneficiaries nominated. So that's very, very important. All those accounts will not be transferable easily without a will document. So what all we need in India? Most importantly, we just need a basic will document, and that is must for everyone. Power of attorney and living will you can have based on case to case basis. Let's say if you want, you can have a power of attorney done in somebody's name, and you can have a living will also, just to outline your what you have in durable power of attorney here. Similar thing you can mention in a living will there. Or if you have very large assets in India or complicated situation, let's say you have a minor kid who is challenged or need special need, or if you have some dispute in the family, or if you have some dispute in between husband and wife, or you have something by which you think that the assets will not get transferred amicably between the all the legal heirs, then farming a trust can protect you. Also, if you are running a business or doing something like that, and if you are afraid of creditors or want to protect your assets, then creating a private family trust can help you in that those kind of situation. So a simple will document is must for everyone. These other documents are optional based on your specific situation. And again, it has to be done for each and every adult who has any financial assets in their name. Gone are those days where somebody dies without any assets. Like I remember, like my grandmother and all, my grandfather, they did not had anything at all. Like when they died, like not a single paisa to their name. Uh, but those kind of days, I think, are gone now. Nowadays, everybody has some kind of financial assets, so that means that a will document is compulsory for everyone. Again, how we can do it in India? For like local lawyer or CA, you may need to approach and get it done through them. So again, you need a physical presence and you need to get it done. Or there is another option available online. So again, for everyone's benefit here, also I have partnered with willgenie.com. It's a very leading number one provider in India. For more than 10 years they exist, and they have partnership with all leading financial institution in India like HDFC Bank, ICICI Bank, and NSDL. So all big financial institutions they are partnered with. So they are it's a very trusted name, and it's very well established by now. And you can get like I can engage you with their team, and you can get the your documents done, and I can be there on by your side in case you need any help or any questions or anything which you want to get my help on. So I can be by your side in doing that. And once it is done, you can do it from here for anybody, even like your parents or in-laws who are in India, you can get it done for them from here as well. And once it is drafted, everything is approved by you. Then all they have to do is just print it and get it registered. And for registering also, they will provide local contact in your own city, and they will get it done. So, and once it is registered, then it's a final thing. Then after that step, then nothing needs to be done. So anybody has to just step out of the home just once to get it finally signed. That's it. So just final thoughts that it's a one-time activity for most people. It's not like that, oh, I am so young now, so why should I do will now? Yeah, I have to keep updating it like later on. So it's not like that. If we make the will in a proper way with default clauses and general clauses and not being too specific, if we don't want to be, then we can keep that will for the life. We don't have to amend it or we don't have to update it. Or if we have to update it, once you have the basic will done, then updating it and redoing it, it's not a big deal. Cost to do this will right now is a fraction, a very little fraction compared to what it can cost to your family later on. So as I said, in US, maximum you have to spend is like $599 if you just go retail on your own. In India, the normal will drafting starts anywhere from 15,000 rupees, and then registration and GST including, I would say in about 20,000 rupees it will be done. But if you don't have it, then succession certificate itself takes 6 to 12 months and minimum 2 lakhs to 3 lakh rupees. Just the succession certificate. Then after that, you have to get the individual affidavits done for all those heirs. And then travel cost and everything else, that will be like going to lakhs and lakhs of rupees. And I know personally families in India, like just to transfer their home from their parents or grandparents' name to now to themselves, like it is like a 10 to 15 lakh kind of cost just to get that done. So it's very, very expensive and cumbersome. And as I said, you don't need to list all the assets in the will or these documents if you want the general distribution. Like if you just have default as a spouse and contingent after that default as kids, and then you have to define one more after that. Like if both kids and wife are not there, then who should get those assets? So like that, if you have general distribution clause, not specific to a person or no asset specific asset is going to a specific person, then you don't have to list all the assets. You should list the asset only if you want, let's say this land should go to this person, this particular home should go to this person, or this particular jewelry or something, anything specific. If you want to give to a specific, then only you need to list it. Otherwise, you can have a general distribution clause. And as I said, you don't have to mention any values there because all the values will keep changing from time to time. You can either mention percentage basis or as a whole, that entire thing goes to this person, or 50% goes to this, 30% goes to this, something like that. So that way you don't have to mention any values, or if you want to give some specific amount to somebody, then you can mention that, okay, at my death, this much amount should go to this person, like that, something like that. So you can get full control and flexibility and peace of mind while you are still alive and healthy, sound, both physically and mentally, rather than relying on not relying, because you're not relying on anybody. Like you're just leaving your family at the mercy of all these people, like lawyers and courts and everybody. So be responsible. Don't be responsible about this fact. We are doing so many things every day. Creating so many assets with so much hard work and labor. So it's our responsibility to protect it as well and make sure that family don't have to deal with financial stress and this other kind of stress apart from emotional stress they would be going through anyway in case of our untimely demise. And I don't wish anybody die untimely, but even in timely manners, everybody will die one day or other. And even in that situation, even if you die 80 years, 90 years, or 100 years, this would still apply. So there is no point in delaying it and waiting for the right time to get it done. So I would humbly request everybody to get it done, and any help or any suggestions or anything where I can help you, I would definitely do that. But get it done. Any which way you want to get it done, it's up to you. I have shown all the options available. So, but only humble request is get it done and don't leave it for chances, you know. So, so with that, I would like to end here. In case if anybody has any questions or comments, I can take it, and then we can wrap up the session.
Prabhuji, Satya here. I'm just saying that in India, here
Mm.
so I had a plan. This year I opted the plan for next year. So fortunately, January 2026, I will do the things for US. For
Yeah.
India,
Mm.
the Willy, what is the Gili or what the
Yeah.
site you said?
Right.
So for that also I have to go in person, right?
No,
One time.
only if you are doing for yourself. If you are doing it for your in-laws or parents, that can be done from here, and you can
No,
get it
I am doing
drafted.
for myself because no one is in
Huh.
my family.
Yeah, right. So if you are doing it for yourself, you can get it drafted. Only thing is that you can get it drafted and signed by few witnesses here, two witnesses here, and that will become formal will. Only thing is that when you go to India, you can just get it registered in a local court. So then it becomes even more formal and official.
Oh, okay, okay, okay.
But
So
as long
there
as
is
you get
no
it
online
drafted,
like.
yeah, so as long as you get it printed, drafted, printed, and signed by you and two witness here, that will still holds true in the court of law.
Okay, means, and what about if it is get notarized? US notarization is not valued in India, right?
Yeah, it will not be. See, in India, you don't even need to register it or notarize it. That's not a legal requirement. But only thing is that if you register it, it become more formal and authenticate so that there
Right.
is no chance of any dispute in future.
Yeah, right now I'm facing the dispute because of the
Yeah,
same thing. That's the reason I am
yeah,
facing
right.
a big dispute.
That's why it is always recommended to get it registered so that, in future we can safeguard ourselves from any kind of dispute from anyone. But don't wait for the time. As I said, like even if you get it documented and get it printed and signed by two witness here and yourself, that would still hold true in the court of law. And when
Okay,
you go back to India, then you can just simply get it registered.
okay, I will. Yeah, definitely I will. First, I'm going to do this US one.
Yeah,
India, only one thing is there, so that is not a big deal. But okay, thank you, Prabhuji.
yeah. Okay, so I will just take a couple of questions from the chat, simple ones. So executor, no, it can be from the friend or family. You don't have to have a lawyer as an executor. And it is recommended you have somebody who you trust and who understand you and your family. So executor should be somebody like that, not like a professional. Only in worst to worst case, when if you don't have anybody, then a professional can be appointed. But again, preference is always to have somebody from friend or family. Then question is like, can we include India property in US will? Yes, you can, but it won't do any good because in India, you should have an India, like a will document in India that would be more authentic and valuable to cover the India properties. So I would recommend to have will in both places for US in US and for India in India. And I think Narari Prabhu asked, like, should we need will or trust? I think I answered that question in presentation already, so that should cover that. And should US will be registered in US court? So again, like, no, as long as it is notarized and signed, you don't need anything else in US. The trust, yes, a trust will get again same thing. It will get notarized and signed by you, so you don't have to do anything. Only thing you will need, like when you transfer the title of your property, like your home, into the trust, that you have to go through a attorney. That take like depending upon your state and county, it's just a one-page deed transfer document you have to make, and any lawyer like can do it for like 100 $150 something like that. It's a very simple process. In a county you just have to file a deed transfer title transfer or deed transfer certificate. That's it. So then instead of your name and your wife's name, your property will say it is in the name of the trust. Then Prabhuji is asking if you use Will Genie. Yes, so they will have a Zoom meeting with you to and go through your situation, and then we'll draft the will for you, and then you will have a chance to review it and go back and forth to refine and fine tune it. So yes, all that will be done. An individual lawyer will be appointed to you, and he will be working with you over Zoom meetings and phone, and we'll get it done. And once you are both are comfortable with the document, then final payment is made, and then they will release the documents to you. Okay.
Hare
Are
Krishna,
there
Prabhu.
any? Yeah, just a minute, Prabhuji. I will cover chat questions first. They are just simple. Is there any tax implication if we create trust? No, there is no negative tax implication for revocable trust. Uh, and no extra implication or no negative implication. So text wise, it's neutral. Okay. Yes, Prabhu.
Yeah, Prabhuji, one question. So, like you making a group of 15, like we need to make a group of 15, or like we can just join the group that you creating
No,
for
no,
15.
no. So like we have this 40 people in the call today. So
Mm-hmm.
if you can just let me know if anybody is interested, and if I get enough interest, then
Mm-hmm.
I will just sign up for that service and then can offer the discount to everyone.
Okay, got it. Okay.
Yeah. So
So
each
we need to
yes.
personally message you, or like
Yeah,
what
yeah.
we
If
need
you
to.
can personally message me and inform me that yes, Prabhu, I'm interested, then
Mm-hmm.
I will have a count, and then I can inform on the community that yes, I got the quorum, and then we can go ahead.
Okay, got it. Thank
Yeah.
Hare Krishna, Prabhu.
Yes,
Uh,
Prabhuji.
so I had prepared this will like about long time back, about seven,
Mm-hmm.
eight, when the kids were little as well. Does
Mm-hmm.
it require to retouch it back again, like when the kids has grown up, or the changes in some? Uh,
It depends on the wordings of the will. So you may have to go through it once and make sure that everything holds still true based on your situation. And yeah, so if there is no updates needed, then probably you are good, because kids becoming major does not make much of a difference. Only thing is that let's say if grandchildren's born, and then because of that, if any situation change, or let's say after marriage, you see the need for one person maybe more than the other person. In those specific kind of situation, if you want to like not distribute equally, or whatever, like I'm just throwing out
mhm.
some scenarios. So just read through it and see if everything you are still okay or comfortable with, then probably no need to make any changes. But if you think that it's outdated based on your current situation, you want to make some changes, then yes, then probably it's good to get it updated or redone.
Okay. And regarding related to that, the lawyer firm who helped at that time to prepare it uh, during the COVID time, they wind up
Mhm.
and they no longer exist. So
It
it
doesn't
is
matter. Yeah,
doesn't.
yeah, even if you produce your original document to Will Genie, and if you want to update, they will take care of it and then update it and help you with
I
that.
mean, here in US, I was referring to.
Yeah, here also means anybody, even if you go to Trust and Will, and then we can put our existing document there, and they will extract it, and then they will suggest if any changes we need to make.
Okay,
So
thank
in
you.
both
About
cases, we can take the existing document as a baseline, and if we want to update anything, we can update it. And anytime you make a new will, the old one anyway by default become null and void. So the only latest one holds true.
Sounds good. About the India, I never personally thought about there is a will process need to be taken care as well.
Right.
Always thought that the Hindu law, by default, it automatically goes to your kins. So,
No, but it goes to all the kins, not one particular kin. So and
mhm.
it goes equally. All the daughters are also equal share. So let's say if you have a big family of siblings, and their siblings have their childrens as well. So then it will become a nightmare situation to get the properties transferred.
Sounds good. Thank you.
Yeah. Okay. Is there any special requirement for non-immigrant in US? No, there is no special requirement. You don't have to be citizen or non-citizen. It doesn't matter. As long as you have assets in US, you can create the will. Whether citizen or non-citizen, it doesn't matter. Okay. Should we do India will online or in person if you're planning to travel in next few months? If you're planning to travel, then also I think that you won't not have enough time to go through the lawyer's office, sit with them, explain your situation, get it drafted, because it has to be drafted and everything, and that may takes like few weeks of time. So depending upon how comfortable you are with that person, whether you know somebody personally already, and he can make it ready by the time you go there and get it done while you are still there, that's okay. But otherwise, online option is like very comfortable. You can get it done anytime you want from the comforts of your home. Another question is, if the kids are major and we still have a mortgage on the home in the US, is there a need to have a trust? Technically, no, because if kids are major, then sorry, if kids are if kids are major, then they can acquire the property on their own, like after the transfer. If you have in will, mention them as the beneficiary. So then, without trust, if they are major, they will able to get the title transfer in their name. But if any one kid is minor, then I would still recommend to get the trust done. Okay, so Krishna, Kishore Krishna Prabhu,
Yes,
you have
Prabhuji.
question? Yeah,
Yes,
Prabhu.
thank you.
Go ahead.
Thank you, first of all, for having this session. It helped, especially for the Indian side.
Yeah.
I have a question. When we amend the will or trust,
Mhm.
the date changes because we have a new
Yeah,
trust date, right? So do we
right.
need to go and fund all these institutions and maybe
No,
the
no,
deed?
no.
No.
No,
Okay.
because all these trust documents and everything is applicable, like go share with any institution or anything, only in after your death. So your executor should be aware that you have created or updated the document. So executor must
Okay.
be aware, but not the institution, because institution has nothing to do with it unless you are until you are alive.
But when we amend it, they don't care how many times we amend it,
Yeah,
right?
you can amend it as many times as you want, as long as you are alive and you are in good mental and physical health.
Okay.
And then the latest one should have the executor should have the latest one so that he can produce it. And let's say if somebody else has a older one and then he comes back and then whichever is the latest, which take the precedence.
Okay. Thank you.
Hare Krishna, Prabhuji. I have a quick question.
Yes, Prabhuji.
Prabhuji, so let's assume, right, we have a will and then there's a trust. All the assets are in the trust.
Hmm.
I pass away.
Hmm.
How are the assets then transferred from the trust to the spouse and the kids?
No, so we don't have to put all the assets into the trust. Only house I'm talking about. The bank accounts and all other assets can remain in your individual name. Only thing is that in will you will define who should those accounts be transferred to after your death. So let's say if you say that my 401k should go to anyway, if you have a benefit designatory, so that will anyway go. Let's say, for example, you have some bank account and it's in your name, and you say that all my bank accounts should go to my wife. So after your death, she produced death certificate and the will document to the bank, and bank will transfer in her name. That's it, as simple as that.
And what happens to the property, Prabhu?
Property will remain in trust name. You will be the joint trustee, both of you. And if both of you die, then trust will dissolve automatically. So then in trust, you will define the beneficiary of the trust. So if your kids are major and you define them beneficiary, then they will inherit that property and they can get it registered in their name or their own trust by that time if they have their own revocable trust. Or if they are minor, then your guardian will come in picture and then he will take custody of the property till the time they become major.
Okay, Prabhuji, this helps a lot. So thank you so much, Prabhu.
Yeah.
Hare Krishna, Prabhu.
Yes, Hare Krishna, Prabhuji.
Prabhu, I have a question. So I have a LLC.
Mm-hmm.
So that has to be, I have already made a trust. So
Mm-hmm.
that has to be transferred to the trust. I haven't done that yet.
Yeah, it depends like what kind of LLC is there and what kind of liabilities or credit it has. So I think it's a very specific question. So
Oh, okay.
yeah, right. So yeah, but depending upon the situation, once we get to the process, then there will be professionals available even on online platform to answer our questions,
I
and
see.
then accordingly, then we can go forward.
Okay. Thank you.
Yeah. Yeah, Shubh Vilas Prabhuji, you have hand raised.
Yes, Prabhuji. My question
Yes.
is also on the same line. So you primarily covered the asset transfer,
Mm-hmm.
but in US, asset protection from litigation and other such things, accident,
Yeah.
etc. So will that also be covered in this process?
Yeah, so that is a different process. So what I covered today is a pretty general, straightforward, which is applicable to like everyone. What you are asking about is asset protection trust. So that is a different specialized type of trust. So yes, that can be done, and depending upon your situation, that can be formed as well. And there are some minor trust as well. So for example, nowadays many families I know have a special need child, and parents are worried that what will happen to them once they are gone, they don't want to depend on siblings, or they don't want to, they want to create something for them, for that child, so that they can be taken care of nicely. So then for that also there is a special type of trust you can create, which is called a minor trust. And then you can have your wish there, and you can appoint a guardian or executor there who will take care of that minor for the lifetime. And then you can transfer the assets into that trust, which will fund the care for that particular child. So like that, there are some special situations are there, and you can have a trust specific to that situation as well.
And this asset transfer, real estate asset transfer
Yeah,
through will versus through trust, is
yeah.
there any difference between the step-up basis?
No, it has nothing to do with step-up basis or tax implication. It's just a ownership transfer issue. So it has no implication with tax. Tax is it's a different thing on its own.
So in both the processes, it will go through the step-up basis.
Yeah,
So
once it get after death, once it get transferred, the whatever the tax laws as per that particular time, that will prevail. So just as you are transferring through trust or through will, it will not have any negative tax impact.
okay,
Like
thank
it's
you.
tax neutral. Yeah.
Okay, one last thing in the will, can one be more specific? Like if I have a 465, then this happened, and if it's 465, this one.
Yeah. Yeah, it's up to you, whichever way you want to draft it.
Okay, thank you.
Yeah, it's completely flexible, and that's what it is for. Like you can put all your wish and thoughts into it, and conditions. Like even in trust, you can put conditions. For example, let's say even if your kids are minor, then you can put a condition until they become major, they will not get any access to any funds directly, or their education should be funded from so and so, or things like that, or this house can be sold, or this cannot be sold until they become major, no, or even after becoming major, ownership should not be transferred to them until they become responsible, things like that. So all those kind of finer points also you can mention as per your specific situation and wish.
Thank you, Praveen.
Yeah, another question in the chat is, can executor be one of the beneficiary? Yes, absolutely. There is no restriction on that. Yeah, if you amend the will, then yes, it's better to do the re-registration, so that because then it becomes formal and authentic. Otherwise, somebody, if they have access to that old registered will, then they can say that this new will is a forged will. It's not authentic. So if you are making any formal updates, then it's better to get it re-registered.
What is this word? Executor is same as trustee, or is it two different things?
Beneficiary. So beneficiary can be executor. So let's say if your parent is writing a will or something, so you can be both the executor and the beneficiary. So you can say that your parent can say that, okay, my son will get the assets also, but he is also the executor of the will, like that.
And who is trustee? In US especially, this is used a lot, this term.
Yeah.
Who
So
is trustee?
so in trustee, there are two terms, grantor and grantee. So if you are forming a revocable trust, then as long as you are alive, you will be the trustee, and you are granting the assets into that trust. And then you define the beneficiary who will become the owner or the trustee after, like not the trustee, like they will become the beneficiary. So you will be the trustee of that particular trust as long as you are alive.
And we can allocate even like non-profits, temples also as beneficiary.
Yes, absolutely. That's the benefit of it, because ultimately you want to nominate your charity while you are still alive, and then they can get it without any hassles after your death. Okay, so I don't see any other hands raised, and I'll
Hare
check
Krishna
questions.
Prabhu.
Yes,
Hare Krishna
Prabhuji.
Prabhu, thank you so much for the webinar. I have a question. I'm still trying to understand the distinction between will and trust. Like I know when we use the will, and I kind of understood trust, but as the question answers are going on, I'm getting a little confused when you exactly use the trust. So if you can just try to clarify when exactly we use the trust. I know you mentioned about if you want to designate a guardian and you want to put a house on the
Yeah,
trust in case something happens to you
yeah,
and your
so in
spouse.
a yeah, in a very simple way, if your kids are minor, then trust is a must.
Okay.
Yeah.
Mm.
So anybody who has a minor kids, then it's must to have a trust.
Okay. And then in the trust, you would put everything, like it could be tangible assets, like could be car, house, bank accounts,
Minimum,
whatever. You put all that
minimum,
in.
yeah, minimum your primary house, minimum, or any
Okay.
immovable assets. Those, yeah, your immovable assets like real estate, house, property, that you should put in that trust. Other bank accounts, financial accounts, that's not required. As long as you, because if you have trust, then I'm assuming that you will have will also along with it. So, so at least the properties you should put into the trust.
Okay. Okay. And you mentioned about how the beneficiary can be the executor of the trust, the will, sorry. Say for example, if I make my wife the executor and something happens to me, but then as you mentioned, anything is possible. If both happen to pass away at the same time, then what
Right.
happens? Like if she's the executor of the will, but something happens to her as well.
That's why I said in the beginning, like you always have to have a contingent executor as well. So one is default
Oh, okay.
executor, and
Right.
then another is contingent executor,
Okay. Right.
who is
That's correct.
outside
Yeah.
of
Yeah.
your
Yeah.
immediate family. So like that.
Okay. Got it. Yes, Prabhu. Thank you so
Yeah.
much, Prabhu.
Yeah.
Hare Krishna.
Okay. Any other questions? I don't see anything. So one last chance. Anybody has any question on the call? Okay, so I think thank you everybody for joining and giving me this opportunity to share this information with you. And again, as I said, I humbly request every one of you to take care of this. And it's very, very important. We wish, and I sincerely wish that nothing happens to any one of us, but ultimately one day it will happen to every one of us. So better not to wait for the time and get it done and be peaceful while we are still alive and make our family members and our next generation also peaceful, knowing that we have taken care of this very important step in our lifetime. So with that, I would like to end here. Once again, thank you very much, and
Thank you, Prabhuji.
we'll
Thank
see
you so
soon.
much.
Thank you so much, Prabhuji.
This
That's a
was
Yeah,
wonderful, actually,
yeah.
session you have taken. Thank you, sir.
this was
That's very
great. Thank you.
Thank you. Hari Bol. Hare Krishna.
Haribol.